The California state legislature is taking on the gun industry.
That's right. Lawmakers have proposed a bill that would give private citizens the right to sue gun manufacturers and sellers. The bill is modeled on a new Texas law that allows private citizens, instead of the government, to seek penalties against abortion providers. California's bill would apply to those who manufacture, distribute, transport, import, or sell assault weapons.
The bill is one of 4 pieces of gun legislation in California. Many gun advocates say the proposed law infringes upon their Second Amendment rights.
For more on all this, I want to bring in Robert Spitzer. He is a distinguished service professor at SUNY Cortland. Professor Spitzer, thank you for joining us. So can you explain the motivation and theory behind this bill and how it sort of mirrors the current trend of these state abortion ban laws that we're seeing?
Well, the motivation on its surface is political, but there is also an important policy component. And that summarizes the 2 things that the California legislation and the Texas anti-abortion law have in common. One is that they are putting into their bills or law a provision that essentially takes governmental power and gives it to a private citizen to try and implement state policy through private litigation. And we know that the state of Texas did that so their anti-abortion law could avoid judicial challenge in the courts. And indeed, despite an emergency appeal to the Supreme Court let the law stand, at least for now, in Texas. And that certainly has made anti-abortion supporters happy. The California law has that kind of provision where private citizens can sue gun manufacturers for up to $10,000 if they improperly, illegally market or sell assault weapons, for example, or 50 caliber sniper rifles, things like that, or engage in certain kinds of advertising or marketing practices. But the state of California continues to have the ability to prosecute these kinds of cases as well. Whereas in the Texas law, the Texas state government and its prosecutors and local prosecutors are actually barred from enforcing their own anti-abortion law. Mm-hmm. And again, that's because they wanted to avoid judicial scrutiny of the law. So you've got those 2 kind of factors at play. And politically, of course, California and Governor Newsom have made very clear that they were going down this path of giving citizens this kind of power precisely to say, look, to the Supreme Court in Texas and the country, you've let this go in Texas, so we're going to do this now to go to pursue gun manufacturers and gun activities and weapons and try and stop us.
Professor Spitzer, we know the U.S. Constitution specifically says people have a right to bear arms, but not the right to an abortion. How could that pose a challenge to Democratic lawmakers if this piece of legislation goes before the Supreme Court?
Well, it's really not. It's important to point out that there are certain rights that are expressly stated in the Constitution, like free speech, like the right to keep and bear arms, although the interpretation of the Second Amendment's right to keep and bear arms changed dramatically, even though it's written in the law, in 2008 in the Supreme Court's Heller decision, where they changed the meaning of the Second Amendment from being a militia-based right to being a right attributed to private citizens for self-protection using guns in their homes. So even though it's an express right, the court decided in 2008 that it meant something very different from what our prior history had said it meant. Now, as to right to privacy and the right to have an abortion, there are Supreme Court cases, many cases that have supported and endorsed that right. Privacy is not mentioned in the Constitution or the Bill of Rights, and obviously neither is abortion, but there are many, many rights that we exercise that are not expressly stated. They are implied in the document. And that category of implied rights is recognized as long as the Constitution has been around. So the fact that abortion isn't mentioned isn't really the critical matter because it is legal as of now, and that does point out one notable difference between the Texas law and the California measures.
Always a controversial topic for sure. Professor Robert Spitzer, thanks so much for your time and your insight.
Good to speak with you.